read this, as we always read for the lecture and record it. So the event lecture will be recorded, streamed, and podcast. The video recording will only capture the speaker, instructor, and students will not be available. Your voice, however, may be captured if you ask a question. If you do not wish your voice to be captured, please speak to me so we can determine an alternative means for you to participate. Or feel free to write down questions and pass to a staff member who can read it for you. We're going to start with the second workshop in the semester. The first one we did last time with research question. This one we talk about copyright. And next one, in November, we're going to focus on job searching by the alumni of our school. They will talk about their experience in job searching and also their experience to be assistant professor for half a year or 1 year, see how what they want to share. So that'll be in November. Also, at the end of October, we also have 3 students publicly going to present their dissertation. So by which is October 31st. That's a Friday. It's a little bit different. We'll send out too. And today I want to thank Anne for the food ordering from Beans and Barley. So if you like that food, you can send her. If you don't like food, again, join us. Laura, where's Laura? Laura is going to order food for the next event, which is a dissertation presentation. So if you have any suggestions or anything, let Laura know. Laura, you want to say something?
Oh, yeah. So this is just like a general thing about food allergies and cultural sensitivity. I have celiac disease. I can't have gluten. I'm also deadly allergic to mangoes, so don't think of that. But when you take a spoon and put it in contact with one of the other soups, this goes for vegetarian, vegan, kosher, halal, gluten-free, and then you put it in the other soup, it is no longer safe for people to consume. This goes for all food. So and we're going to have guests who might have other restrictions, so it's just a good thing to keep in mind.
Okay.
Yeah.
Thank you. So that's good to know. Probably we didn't realize that's at the beginning too. And also, Molly is going to order food for our November workshop. So this semester was so far okay. Probably we're going to have another one, public defense, in a student research presentation in December. So we still probably need one more student to volunteer for the food ordering. So if you love food, share with us. That's important too. And also another quick announcement. For the Research Publication Award, in the past we send information to the dean. After talk to Tom, we decide this time we're going to change. Will be the doctoral committee will make a decision. So I will send an email around regarding the awards part. So you can send an email to the chair of the DPC. I will send an email with detailed information. That's another thing. I also want to welcome the people from the 21st Century Center. So thank you for joining us today. Okay, where is Tom? We have to. Tom. Tom, you look like a VIP, so everybody's here. Yeah, many of you probably know Professor Lipinski. He was a professor here several years ago, right? And now he comes back as a dean of the school. So today is a combination of a workshop and also meeting with the dean. So if we have more time, we can talk at the end. If you have any question for the dean, then that's the opportunity you can ask questions, right? So Tom is an expert in copyright. You probably read his book and his articles, but I don't want to spend too much time to talk about his credential. So Tom, thank you.
So we're getting more copies. It's a copy of a publishing agreement with a book contract. So at the end, we'll take a look at that. And so contract's always a little blend of copyright and contract. So that's an actual contract I received from my next publisher. I haven't decided whether I want to go with them or not. So we'll look at that at the end. And first, I want to talk a little bit about copyright. And in the academy, some things you might want to think about as you do your research, you collect your data, you move towards publication, whether it be a book or an article. Just some things that sometimes publishers don't quite always understand, or things that they maybe get a little hesitant about, maybe because they may not understand really the copyright law either. And you'll see some clauses like that in the contract. So just some basics. I do teach And I had Doxies take the course, and Jeremy's taking the course, and some others, and so I'll be starting to do that again this summer. And it's a legal issues for libraries, information science, and about a third to maybe not quite half, but a good third of the class is copyright and contract. We cover privacy and free speech issues as well. So some of you may know a little bit about copyright, some of you may know nothing about copyright, or at least American copyright law. It's similar around the world because many countries are part of the international copyright community. There's a number of international treaties, so there's a general framework for every country to implement in their own laws, but every country kind of gives a little different shade and different interpretation. I have some copies of the PowerPoints too if you want those, and Laura's got extra copies of those. So I'll just talk about these things real briefly. The origin and nature of copyright, something about exclusive rights, which you will have as an author, as a creator, and the duration. And then some liability issues, so some things maybe you have to worry about, but then some protections
You cannot put it.
that are built in. And then some specific provisions, fair use, which you will probably use a lot. Section 108 less, it's more of a library and archive provision. It might be nice to kind of understand that. And then some section 109 are first sale rights, which are rights to distribute the work. So you'll see that all. In the United States, copyright law is in our Constitution, so it starts from there. This clause in the Constitution is also our patent clause. The first copyright law was enacted federally in this country in 1790, so it's been around a while. Some say the origins of modern copyright laws trace back to England and the Statute of Anne and the original rights given to stationers to publish with Crown authority. We've interpreted things a little differently as it evolved since then, but so copyright law is based on the expression of this idea or this concept in the Constitution. So it's a federal statute. We really don't have common law or state copyright law anymore, except strangely for sound recordings fixed or made before 1972. Don't ask me why. No one knows why. They've done reports and nobody can figure out why it was left out. So it's basically a federal law now, and it's statutory. So we can look at the statute, but sometimes it's not very helpful to figure out what it means. So we have different tools, legislative history, House and Senate reports, and if you ever read a copyright case, like you read some of the more recent press cases, cases that made it into the press, like the High Trust decision, Google Books versus Authors Guild, the court will sometimes look at the legislative history of these reports. What did the Senate and the House think? The judiciary committees where all copyright legislation starts. What were they thinking about when they changed the law? What problem do they want to solve? So sometimes those are helpful, and the courts do use those to interpret the law. So something like fair use, we really know what fair use is today because of court cases. Sometimes the Copyright Office gets involved. They may create regulations, they may issue a report, they may give their interpretation. Regulations have the force of law, but the reports of the Copyright Office do not. And you'll hear a lot about, if you read enough copyright literature, about so-called guidelines. Most were created back in the 70s, some have been more recent. They were trying to interpret what fair use meant, because as you'll see, it's an application of 4 factors that are purposely vague, and it's very fact-intensive. Every case can be different from the other. You can still learn patterns and trends. So people said we need help, so they created these guidelines. But the guidelines are not the law, and I would argue they're becoming less and less useful as time goes on because the guidelines were written in the 1970s and they were never amended, and so they're static. They're a window into what copyright law looked like 30 or 40 years ago. And unfortunately, they were adopted, classroom guidelines, by many school districts, just word for word into their policy. And maybe that might have been useful 25 years ago, but maybe not so good today. And then a more recent concept is best practices. So the archive committees issue best practices, documentary filmmakers, a lot of different groups have issued best practices. ARL recently released some best practices on fair use. And they also have limitations. It depends on how they're constructed. Some best practices are sort of meant to be like models, and some are really not based necessarily, they may be based on practice, but the practice may not be in conformity with the law, so you really haven't accomplished much. All you've done is sort of codified informally, in a sense, bad practice. So that might be what everybody's doing, but it may not be really legally. And again, they can be static as well, unless they're revised from time to time. So you hear a lot about best practices as well. 3 requirements for a cadre. So it just has to be original, a work of authorship, and it has to be fixed. So, you and this typically is human authors. So, there's people that try to copyright, they give an elephant a paintbrush and it paints artwork and they sell it for thousands of dollars and try and protect it. You can't register work like that. The Copyright Office will refuse to register, to accept the registration. Some people have tried to claim that angels inspired them, so they want to claim copyright with the angel, co-author, and it doesn't work. It has to be a human author. But other than that, if you got a pulse, you qualify. And it just needs to be original. It doesn't need to be independent in the sense that 2 people could, in theory, construct the same, haiku on different sides of the country, and they could both get copyright protection in it. So it's not like patent law where you have to kind of figure out this is the inventor. And it just needs to be fixed. So, when you're just thinking about a research project, you're just thinking about a book or an article, there's really no copyright work or property there to protect. But once you start to articulate that, once you start to make an outline, once you start to make some notes, once you start to actually write it, you're fixing it. It doesn't need to be on paper, and it could be in a digital medium as well. So computer records, a file, a drive, that's a car drive. A drive like this, if it's zeros and ones and data in that sense, it's fine. That's fixed. It meets the fixation requirement. Copyright does not protect processes, though. Sometimes it's said copyright doesn't protect the idea, it just protects the expression of the idea. But processes, and I throw that in here because you might be doing particular work that does create a process. Maybe it's a way you create a computer program that processes the way data is analyzed. Now, the computer program, once it's fixed in code, could be protected by copyright, but it might also be protected by another type of protection called patent law. So in the United States, we have a whole type of, or whole category and group of intellectual property, generally patents, trademarks, copyrights, and trade secrets. And trademarks are some type of a logo, a name, a word, a sound that tells you something about the origin of a product's, of a product, a good or a service, is about its origin. So, right, yeah. So this is the little nested with this is. You see this, it's not. If you see the Nike swoosh, even if you can't read the whole word Nike under it, you can tell from a long distance if that's a Nike. So that's the concept of trademarks, but patents can protect processes. And so software is one of those that can be protected under a different nature. If you end up working in the private sector many times, you might run into another type of intellectual property known as a trade secret. So trade secret is proprietary information that you tend to keep secret. things like company lists, preferred customer lists, you'll see are too basic. There's no creativity there. It's just names and addresses, so it doesn't qualify for copyright protection. But it might still be very valuable to your company. And so that can be protected as a trade secret. So we're going to focus on copyright, which are usually the works of authorship that we think of. Here's various different categories. Likely the most common you'll be creating will be a literary work. So it's text material essentially, which does include computer programs. But you could be writing music. Not sure if there's quite a call for that in information science, but you might be working with musical works. And dramatic works. So if it's a musical, it's classified as a dramatic work or a play. You can even copyright pantomime choreographs. They just have to be fixed. So how do you fix a dance routine? Well, you could record somebody dancing it, or you could write it out in certain dance scripts. Pictorial, graphic, sculptural. So artwork, photographs, things of that category. Motion pictures or audio-visual. Motion pictures are a subclass of audio-visual works. Audio-visual work is just images and sounds somehow synchronized. So it doesn't necessarily need to be moving. It could just be a series of photographs that are synced to a narrator, and they move forward in sequence. That would be an audio-visual work. Sound recordings. So if you end up doing some teaching for us and you're teaching online, you record some lectures, you just created a sound recording. Once you record it into Camtasia or whatever you're using. Architectural works can also be protected. And then this sort of bulk category, which you may be running into in the academy, compilations. These are collections of items that could themselves be copyrighted or not. So a classic example of a compilation is a database, because you'll see data, raw data, facts aren't protected by copyright. There's no creativity there. There's no originality there. But many times there's value in having all that data together and in having it arranged, coordinated, and organized in a certain way. And that's what a compilation copyright protects. The way the database is organized, selected, arranged. Collective work, an example of that would be you've been asked to contribute a chapter to a book. You're one of many authors. That would be an example of a collective work. So there's a publisher that's going to own the collective copyright. But you as individual authors to the chapters may still retain your own copyright. And then derivative works are works based on other works. So suppose there's the premier book on reference services, but the original author, I don't know if the Katz book is still out there. That's what I used when I was in library school. I don't even know if Katz is dead or alive. Suppose they want the new edition, and they would like you to write the next one, because now you're the leading expert in reference. That'd be a derivative work if it's based on the original. So usually second editions, those kinds of things can be derivative. You can switch sort of, you can do a translation. Somebody wants you to translate from English into your native language this work. So there's an original author that wrote the book in English who owns the copyright. But when you do the translation, the copyright law says there's some creativity there, and in how you interpret, there's some skill there. And so you are the owner of the translation copyright. So those are categories you may run into in our area. So here's some works that aren't protected by copyright. As I said, facts, names, titles. They might be protected as a trademark, right? I mean, the word Nestle is protected as a trademark, but you can't copyright the word Nestle. It's just a name. It's a title. Facts. Some forms, basic forms, aren't. There are some works in the public domain. That's federal government works only, though. States are free to copyright their works. Usually a state will indicate in their statute what they're going to claim copyright. California, for example, says that state agencies may copyright the software they create, but only the software. Everything else the state of California creates is in the public domain. The government can't claim copyright. And then works that have fallen into the public domain that are so old, and that's why we get into the concepts of duration. Durations. Okay, so let me just mention quickly. If there's one rule that you want to have, at least for working with here in the United States, it's works that are published, that have been published before 1923 are in the public domain. Everything else may still be protected by copyright. That's basically what we would have to operate in. So it's a long time, in other words. But there's room for researchers with things like fair use. So there's kind of there's two things to kind of keep an eye on here. One is, what are your own rights as a creator? And then what rights of other works to use do you have to worry about? Because you may be quoting from other work. You might be critiquing another work. You might be taking someone's data that they've published and trying to replicate the study or to test the study. So you might be using elements of their original work. So all of these things, they may raise issues of, well, what other rights might the author have that I have to worry about? So these are the cluster of rights that copyright owners get: the right to reproduce the work, to display the work. That's our word in our statute, but it's not a very descriptive word. I would cross that out and put in transmit. That's the better word. It's just we didn't pick that word, so it's not really like displaying this, but it's to transmit it out. So if you're going to mount it on a website, send it out, then it's probably a display. Or if you're in the lab and you're beaming every student in your class the same image, that's probably a display as well. But just being one image up is not really a display. You're just showing people it's not a technical display. Performance, I don't know that you'll really be performing, though if you were to read your textbook and record your entire reading of the textbook, that would be a performance of literary work. Derivative works, again, as I mentioned, things like translations, and that is the right of the copyright owner to control derivative works. So if you have a publication and somebody wants to translate it into another language, they need your right as the author to do that. That's a right that you still have. And then public distribution, which is typically interpreted to mean the distribution of physical copies. So that's the rights. I mean, we don't have to remember all these, but it'll kind of be a setup to looking at the book contract and kind of getting into some of the nuts and bolts of what's fair use, what can I really use, what do I have to worry about. There are some very important provisions for libraries. Just to mention that if you are ever an employee of a nonprofit library or education institution, and you're doing work within the scope of your employment, so those of us that are getting paid by UWM are employees of an educational institution, and if we happen to, and we're doing research as a part of our job, or we're doing some teaching as a part of our job, and we happen to make copies, and we think we're within the bounds of fair use, if it turns out that maybe we're not, then what happens by law is the court would have to, what we say, remit damages, which means if I'm an educator or you're a TA and you're teaching a class, you're making copies, you want to hand them out in class, and it turns out all of that was those are infringing copies, then the most in damages that a copyright owner could get from suing us would be zero, or from suing you would be zero. And few people are ever going to sue you for $0. Case in point, Georgia State got sued for $0 because the publishers felt they just had enough with their user practices. But if you're within reason, you believe, and you have reason to believe that something's fair use, then you have this huge protection, which is one reason why many educators and libraries don't get sued that often for copyright infringement. But you have to have some notion, because many years ago, I used to do some tax law and criminal tax defense, and I never had a defendant who believed they broke the law. Everyone always believes they're not breaking the law. So, you have to believe. That's easy. Everyone always believes it's fair use. But then you have to have reason to believe, which means the court is going to say, well, are you within the ballpark? You might be wrong, but did you at least have the objective reason to believe that it was fair use? So that's why it's good for educators to understand some sense of what fair use is. So I'll talk a little bit about fair use. Before I look at these factors, are there any questions up to I know that's a lot of information, but yes.
Just a real basic question. When you talk about in the academic setting, if you're sharing an article, is there any difference between sharing it electronically and sharing it physically?
I suppose in terms of the copyright law, if you were to share it physically, they would look at that as a distribution. If you were sending it to someone electronically, they would probably think of that as maybe possibly a display. But it's still, and the other difference is, suppose you pick this up at a conference, so, somebody hands out the paper copy, and then you want to give it to your colleague when you get back. There's really been no copyright transaction there. However, if you take the copy that you physically received at the conference and you scan it and load it, now you've made a copy of it, and you're triggering one of those exclusive rights. And you may trigger another one when you send it out, or when you post it on a website or share it with a listserv or a discussion group or something like that. So you will probably trigger an exclusive right in either of those transactions, but in the one where you maybe are scanning it first, you're triggering additional rights of reproduction. Anytime you scan something and load it, you're always triggering a reproduction.
You mentioned lectures that we might create for classes that we teach. As employees of the university, do we retain the copyright, or does the department or the university? Or
I just had a conversation with someone from legal the other day. Having been here 2 weeks now, I've already been in legal. And my recollection was of being a faculty member here too, is that the University of Wisconsin system has a fairly liberal rule in I'll just go back and forth. I guess I'm being recorded, so I have to watch what I say. But in the interpretation of the administrators in the UW system, they are, I think they kind of say, you have a lot of retention rights. They sometimes position themselves as if they're granting those to you. I would argue as a copyright lawyer who used to be a faculty member and still kind of is, that you have those rights in your work product, in your classroom products, lectures and things of that sort. There's very, very strong case law in our circuit, or in Wisconsin, Illinois, Indiana, or in one federal appellate circuit, that say that faculty have this tradition, this historical right of really controlling their work product. The UW system rules are consistent with that. Put that is the easiest way to say it. What wouldn't be, or what the university might claim that the courts would say belongs to the university, would be maybe you end up being on a committee and you're charged with writing, like a task force on advising on blah, 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 blah. So you're writing kind of an administrative document. The campus would probably say that's ours. But your traditional work product in terms of research, scholarship, and teaching is yours. So I think, did they get a release, or well, so let's have that piece of information. But then there is one could argue that there's an implied license that at least the campus has, so that when you record something and put it on your website, we don't have to get your permission for your students to view it. Putting it on an open site so the whole world can view it, well, that might be something a little bit. You can see that dynamic. So I'm not sure whether they use release. I'm looking at two faculty members here. Do you sign any kind of release when people are? So it's kind of an implied license. You create something for your class. But it shouldn't be something that people are just taking and using. The university will say you do have some vested rights. That's not true everywhere you go. So if you're out there and you start interviewing for academic positions, you might want to ask what their policy is on ownership of work product, of data collection, and of teaching materials, because some systems will not have that same rule. And there are some cases from different states around the country that take a very conservative position, because there is a concept in copyright law known as the work for hire doctrine, which generally says that if you create something in the course of your employment, it belongs to your employer. So if you go and work in the private sector in the IT area, you will probably be governed by the work for hire rules, and any software you would write for work or other documents you would create would belong to the employer, unless you had arranged some other contractual arrangement. So the default rule is the employer owns the copyright. The employer is actually the author. Other questions? Good questions.
Can I just point out too that also if you, like for example, if you're an adjunct somewhere and you get asked to create a course online and it's done under work for hire, you get that one contract, you create the whole stuff, and then they can let other people teach using your material. So that's why it's really important to know, because then you don't have a job anymore and they use people that they already have. So you give them their expertise and then they use it. So
that's an interesting scenario too with the adjuncts, because the copyright law, in the minds of the copyright law, either you're an employee or you're an independent contractor. And there's a whole set of factors that you use to figure out whether you're one or the other. If you're an employee, then in general you have this work made for hire rule, except in the case of generally higher education that the courts will support, or that academic institutions' rules will support. But when you go to the independent contractor realm, in theory, the independent contractor would be the copyright owner. So that if you're being hired, you need to consider carefully, what are you being hired to do? If I were the employer now, I would say, yes, I'm going to hire you, Nadine, to create this course for us. I'll pay you X amount of dollars, and then I will clearly state that I want you to give us the copyright for this X amount of dollars, and then we'll use it however we want. So the default rules might be a little different if you're an adjunct. So if you do start adjuncting for other institutions, you want to make it clear what it is you're getting paid to do, and what rights they want to take away from you. They should be clear about that up front, because if it's not in the contract, you'll win that battle as an independent contractor. It'll stay yours. Any other questions? Yeah, it can get very tricky very fast. But so fair use. So this is your friend. Fair use is your friend. It supports a lot of what you would probably be doing in a research setting, in a writing setting, in a teaching setting. And it's 4 factors. Okay. And if you look at the statute, it's found in section 106. If you Google 17 U.S.C. 107, you'll get this basic statute. There's not a lot of explanation in the statute. It's basically these 4 factors. There's an introductory sentence that talks about the following uses can be fair use, and it does list teaching. And it does list research. But it says in order to figure out whether research or teaching or any of the other things that are listed could be fair use, you have to look at the factors. And that's, as I said, it's a very fact-based, case-by-case study. But as we build more cases, we can kind of figure out, we have a sense of where the general direction is. So I'll go through these rather quickly, and then I have some examples, some specific cases that kind of are in the research area, or they involve things that you might be doing in your own work. So you first want to look at the purpose and character of the use. Is it commercial or is it non-commercial? And that's different than asking whether it's going to be personal, because it could be a personal use that's still commercial. If you look at all the downloading cases where people were they were not selling the music, they were just either sharing it or just listening to it downloaded from somewhere else. But the court still characterized it as a commercial use. And the one question to ask, whether it's commercial or non-commercial, is, are you failing to pay the customary price? If there's a market out there and an album is for sale at X amount, or now a tune for 99 cents or $1.29 or $19, and you're getting that music without paying for it, that's probably a commercial use. It's failing to pay that customary price. Is it substitute or transform? And that's really the key to the first factor, because it matters less really whether it's commercial or non-commercial. What really matters is if you have a commercial use and it's transformative, this first factor is still going to weigh in favor of fair use. And transformative uses are the kinds of uses that we use all the time in the academy. We're using something as an example, using something to illustrate a point, using something as a historical reference point, critiquing something. These can all be transformative uses, as opposed to substitute uses, or that supersede the need for the original. So a classic example of a substitute use would be creating a course pack. It's a substitute for an anthology that some publisher might want to put out. And that's why generally people pay for course packs. But if I take an article, and suppose that it's a seminal article in this subdiscipline, and I scan it and I load it on the D2L page, and I build an entire week's discussion around that article. We tear it apart. You have to write an assignment based on it, or you have to critique it yourself. You have to analyze the methodology in the article. How would you design the methodology better? I mean, you really use that article, tear it apart, and build it back up again. I would argue that's a transformative use of that article. Whereas if I post an article on my detail page and I just say, yeah, we're going to talk about fair use this week, and this is an article somebody wrote on fair use, please read it. That's probably a substitute, because the article was originally published to be read. I'm asking you to read it. You're doing nothing more than what the original use that it was intended for is. So you kind of see the difference between substitute, transformative. Give you another example of an image using a photograph in an illustration. So suppose that I'm an artist. Maybe I take photographs, maybe a photojournalist, or maybe I'm just a graphic designer and I do poster work and things like that. And so this was based on an actual case a few years ago. There was a book that was written about it was a history, a timeline, and it was put together in timeline fashion about the musical group Grateful Dead. So along the bottom of the book, on every page, was this timeline, and then it was a very visual book that had lots of illustrations, diagrams. There was some text. They had reproduced copies of tickets, tie-dye T-shirts, all sorts of stuff, and about 7 posters from the 1960s for Grateful Dead concerts. And the copyright owner on these posters sued the publisher. It was a commercial publisher for including, the images of these posters in his book. And there was clearly a market, a continued market for these posters, either as reprints, because at the beginning of every semester, down at the beginning, they still have the big poster sale, okay? Or maybe somebody would want to put out like a Grateful Dead calendar, so they have the big calendar, you could put that up on your wall. So there would be legitimate uses, a legitimate market for, demand still for these posters. But the court said, well, yes, but you're shrinking these down so they fit on the page of a book, and you're not really using them as art or display or any kind of visual. What you're trying to do is to show, the history of this band and how the concert posters kind of are a part of that history and reflect that history. The court said that's an entirely different use. Another way to think of substitute is, because courts keep the incentive idea behind copyright in mind when they analyze fair use. Copyright, the purpose of copyright is to create more information in society, it's to generate knowledge, right? And in order to do that, we give these rights to copyright holders, economic rights, as an incentive to create or to publish. And so courts will want to understand, if we decide this is fair use, are we going to impact that incentive? And in the case of the posters, if I'm a graphic artist and I create advertising poster work, and somebody wants to create posters to sell at college campuses, that might impact my incentive, because I'm thinking that's a legitimate market. Yeah, I've got the original print and the reprints, and that's my livelihood. But I'm not going to be disincentivized if somebody comes along and wants to write a book critiquing commercial art in the year 2014. Typically that's not a market that I would want to enter. Most artists don't critique themselves, and some do, but you don't write a book review on your own book. Someone else writes a book. So those kinds of uses really aren't going to impact the incentive, and they end up not being a substitute or superseding. They're actually transformative, and that's kind of the key, I think, in current case law. The nature of the work, published or unpublished, courts like to protect unpublished works slightly more. So if you've got, and there have been cases involving unpublished letters, people doing historical research, autobiography works, letters of the author Salinger were involved in one case, the letters of I think the fellow that wrote Naked Ape, I can't remember his name, his letters. So there's been litigation a lot of times over unpublished works, unpublished manuscripts, unpublished letters, things of that sort. And then the other concept is this thick versus thin, and the thought is that under the second factor, works of fact or factual-oriented works tend to be protected less under copyright law. There's more generous fair use. So if you look at the case law, you'll see that scientific works tend to be thin copyright. So you have much more fair use rights using fact-based works. News stories, for example, scientific articles. Not to take anything away from the scientific researchers, but the way that the copyright law and the courts look at it. They see less originality there in terms of the actual content and data. In our law, many years ago, there used to be something which kind of relates to the second factor, and some countries still protect this. It's called sweat of the brow. So you might have had to really do a lot of work to collect this data, but it's all data. It's just factual information. You had to do a lot of work to uncover it and to compile it. And usually in the European Union, they would give you some protection for that. It's called the sweat of the brow. But under our law, because it's facts, it may just be names and numbers and data and frequencies and things of that sort. It's going to be thin copyright. The actual data won't be protected at all. Working it into an article will be thin, but that doesn't mean it's not protected. It is. It just means that when somebody wants to reuse it, or you want to reuse someone else's data in terms of fair use and extract it out of the article that they published, this factor is going to weigh in your favor. And if you're critiquing the original study, you're saying, no, I've reworked the data and these conclusions in the article were wrong. A court might look at that as a transformative use. So you've got two factors in your favor, and the courts will actually go through these factors in this order and sort of give a yes or a no at the end of the discussion about the first factor. So it's almost like keeping track of balls and strikes. And then the amount and substantiality, how much are you taking? And it's never about a hard and fast like 10% or 15%, 20%. The courts always want to know, are you taking only as much as is necessary to accomplish a transformative purpose? So if I want to show you an illustration, of an object to illustrate the object, I may need to show you the entire object. I have to take 100% of the photograph, otherwise it doesn't make any sense. So in the Grateful Dead poster case, they had a reason why they wanted to have some entire concert posters on the page of that book. They couldn't just take some sort of magic 10% or 5%. And that's, in kind of the old days when fair use first was created in the 1970s, the guidelines were really based on these hard and fast 10%, 3,000 words, these bizarre limits that have no relationship to really any of the court cases. And then the effect on the market. So you do have to consider like a reprint market and things of that sort. The derivative market, like a translation market. But again, if your purpose is transformative, the courts have clearly said if you are in a transformative market, you're in a book review market, for example, a critique market, then that is not a market the copyright owner can control. You might write a really scathing review, and then no one buys the book, right? Because the colleague got the research all wrong, interpreted the data all wrong. So you might impact the sales that way, but the court won't see that as copyright market harm. So we'll look at some cases, but are there any factors or questions you have about fair use and general items?
Yeah, actually when I wrote a book last time, I have to cite other people's model, their diagrams.
Yeah.
And still, look at the fair use, things that I can claim that's fair use, but the publisher basically thinking it's not fair use, it's copyright. So I have to contact the original copywriter, publisher to make sure they are agreeing to allow me to put in. So I think it can be considered fair use, right? Yeah,
there's a book, there is a case. This first one is actually pretty close to your facts. Somebody took a love scale chart that was in a psychology book or an article, psychology article, and used it in their psychology textbook. And the court said that's fair use. You don't need to get the permission. Some publishers, and I've seen some contracts like this, they will require you. In fact, I was just talking with a colleague from another university who's under a contract like this. The contract wants them to get permission for everything they quote. That's overkill. That's not consistent with fair use. I would never sign a contract like that. But I know there's a couple publishers like that they just really get really freaky about it. And so if you included this diagram, and then were you critiquing it? Were you using it as a tool?
Cited as an illustration to talk about falling on hold. There are models illustrate this kind of issue, so it's a citation of it. Of course, I also gave that credit to saying where it's coming from. So it is my publisher actually have a problem. My own book publisher saying you have to get a permission from them.
If you were using that I think you're using a diagram to illustrate certain points, to make maybe to critique it. Those sound like transformative uses to me. The other thing to also consider is that when you look at the amount, for example, mean, everything doesn't have to be a transformative use. You could include this diagram without any transformational use whatsoever, and it still might be fair because maybe the diagram is one illustration in a 700-page book. And the diagram itself is not an independently created work. It's just maybe part. Now, some illustrations in books may be their own works of themselves, but that would be another issue. Because this is one of many illustrations and charts from that book. So, that might be an impact too. But it kind of really depends on how you use it.
Yeah, I have a related actually solution is I contacted the original author, and they gave me a modified version of it. So that's another way. Actually, I solved some of the problem. If the publisher does not agree, they asked us to pay. Because what happened, my publishers are worried that if you have an online version, then every time somebody downloads it, they might charge money for. So they don't allow me to. If somebody say pay $40 for the diagram, they say no, don't do it because they don't trust that it's only one-time thing.
Right.
Potentially, it could be a multiple time.
Right.
So the best is not to pay anything. That's their solution. They don't pay anything.
Yeah.
So they ask the author to do a modified version of the diagram.
Okay. That makes sense.
Sorry.
But I mean, go ahead.
I was going to say with that, could you almost make that argument to a publisher? If they said, hey, we need you to do all this, could you say, well, no, actually, I kind of don't, or is it like their house, their rules?
Well, I mean, I've talked to one publisher where I said, this is probably fair use the way I'm using it, and I think eventually they said, okay, we'll strike that out. But some just, they're just much more risk averse than others, and they just won't push on it. So you have a choice. You can either try and get them, or you can say, well, no, I've got 2,000 quotes in this book. I do not have the time to go get permission for these. I'm going to find another publisher.
Yeah, it's a crazy too. It's a lot of time.
Especially the quote ones, really, because there's an argument with the diagram that conceivably the diagram might be its own work. So you take 100% of the work. But when you're quoting, a sentence, maybe a paragraph even, of a much longer work, I just can't see how that would be infringing.
Who tends to get sued, the publisher or the author? It looks like it's mixed.
Yeah, the publisher, usually in lawsuits involving things that are published, it's the publisher. Because the publisher is putting out the multiple copies. The publisher may now own the copyright, and the publisher has more money to pay out. Because, I mean, if I'm going to sue some faculty member or a doc student, or if I'm really serious about getting some compensation for the harm I feel that has been, done to me, or am I going to sue, like an Elsevier or somebody that I know? And logically, if I can change behavior, I'll get a much more bang for my litigation buck by having Elsevier change than I would like one person change. So you'll see in some of these cases, it's the publishing, like in this one, and the publisher got sued there. However, here, this is a very interesting fair use case as well. Two authors were suing each other. And the one author did some interviews. Okay, so if you do oral histories and interviews and things of that sort, and your questions are like, you're doing an oral history of, tell me about when you worked at Xerox and you developed X, Y, Z. So the person is recounting to you things from their memory, things that are kind of factual in nature. It's like doing an oral history. Like, tell me about when you were 6 and you broke your leg. I mean, maybe if you were interviewing, the late Robin Williams, you might tell a really, entertaining story about it. But generally, interviews are going to be thin copyright, right? Because they're very factual based. They're recalling something, like an incident, a story, or not always, but they can fall in that category. And this book, one individual author wrote a book by interviewing women about their experiences. And so it was kind of that oral history, factual, tell us about when you were this and that. And someone else came along years later and used the interviews and the excerpts of the interviews that were printed, published in the first book, to sort of reinterpret them in a second book. And so the first author sued the second author, the court concluded when they did fair use that, well, the nature of the use is kind of transformative because you're taking kind of that same data, some of the same interview excerpts that were published, but you're totally interpreting them in a very different way. And they saw that as transformative. When they got to the second factor, they said, well, what's the nature of the work that's being used? The original interviews were thin copyright. And how much of them were you taking? And this is one of those cases where the court actually calculated percents. They said, well, you're really not taking every quote that's in that book. So we see that as fair use. And then when they got the fourth factor to the market, they said, well, yeah, but, these two books are really take very opposite opinions on this, controversial issue. And someone who was really pro this is not going to buy this book, which was pro that. So they didn't really see the fact that this was like, just another version of the same book that might have competed with it. So this ended up being a fair use. This was a fair use. There's been a lot of biography books. Here's an example of them. There are a couple of different pre-existing biographies, and they just took way, way too much. Not that you'd be writing books of fiction, but as I said, editions or sequels would be a derivative work. If you're really just writing the sequel or the second edition, you need to sort the rights out with the first author. Here's another biography book, but this one was fair use because they were just using certain excerpts, and they were kind of doing a critique of the founder of Scientology as well, whereas this was just a straight biography, just borrowed heavily from previous ones. Some more biography. There's a Salinger one. Wright was the author of the other excerpt I was thinking of. This is the Grateful Dead case, and you see the archives are suing a publisher there again. This is a nice kind of pro-archive museum case. That's, I think, why I included it. It's involving the Baltimore Ravens and their old logo, which was created by this artist. They had like a jersey and some photographs and tickets and sort of an array of the first season's tickets. And they created them in kind of like a museum-like display in the lobby, like if you go up to Lambeau Field and you go to the Packer Hall of Fame. And the artist sued for some of those uses. And the court said, no, that's really a fair use. It's not the original purpose. It's in this broader context of this museum exhibit. Documentary films, clips, music in films, as well as movie clips are fair use. Again, its purpose, in this case, for example, I think they used John Lennon's Imagine, but it was kind of it was the end of the world kind of documentary, but it had a very strong religious overtone, so it was kind of a juxtaposition based upon the sentiment expressed in the John Lennon song and the message in the movie. This was the same way. They used an excerpt from kind of a gangster rap song in a film against teen violence. And so it's kind of this, and another way to think of it is, especially when you use clips, song clips, music clips, video clips, and you think, well, the original copyright owner is the author of the song, Lennon or Higgins. And when the court thinks of market, they say, well, it's really not interfering with the market because people don't watch this movie or, view this documentary in order to hear the song. If they want the song, they won't buy the song, they'll download it from iTunes. If you had a website that did that, then you'd be competing. But so the courts don't see that kind of a use, as really interfering with the market. Not only is it transformative, it's just not interfering with that market. So gives you a lot of leeway in terms of fair use for factual-based works. That's kind of the user side. On the other side, for example, suppose you spent a lot of time collecting data that's not protected by copyright, and even if the data gets put into an article, it's going to be thin copyright. If you're really protective of your data, it can't be protected by copyright. That's where there's a lot of discussions and almost conflict between people that want to have open data and then universities that invest money in collecting data. And now with in higher education, there's always this push to monetize a lot of resources that you have. So it's like, oh no, so there's often a debate between we're collecting data, on the university's dime, and we want to protect it somehow. We want to close it. Versus, researchers who might want to say, well, no, I would really want to share the data. I want to make it available so everybody, maybe there's people can see things I can't see. So it's kind of a debate and a tension. And the private sector data that's collected like that will want to be protected through trade secret, through contract, through things of that sort. So that kind of gets into a whole nother issue of kind of which perspective you're coming from and which side you're going to be on. But you have very generous use rights under the copyright law for factual-based works, and you have really very little protection rights. So with that, I'll stop and see if there's any questions kind of on fair use and copyright. And I think we still have. Are we out of time? No, we have some time. Yeah. It ends at 2?
Yeah.
Yeah. Okay, so then we'll look at this too. But any questions on fair use? Yes.
Yeah. Initially, you mentioned that the copyright law differ by countries.
Yes.
And okay, now how can someone be protected internationally because the law has differed kind of differences, I mean the protection between international.
It does get complicated, but the rule usually is that your work is protected under the country's laws where the use is being made of the work. So that if you had an article here or some other work and somebody wanted to use it in England, research in England wanted to use it, they would be governed in their use of the work by English laws or by German laws or the country wherever they are. Not all countries are part of the International Copyright Community, though. Or they're not they haven't implemented all the treaties that exist. But it's generally the rule is the place where you make use of the work is the law that governs. And most countries do have some form of a copyright law.
Then can we call it like if you have a subscription from the publisher?
Yeah.
It's a right for you as a copy against copyright.
Yeah.
Because you pay for the subscription or you buy the textbook, paying it doesn't warrant you have access to it. Or like maybe you made an annual subscription from Serbia or any of the journal, you pay them and they benefit from it. And now, do you have a full access for the utilization of the content?
Yeah. If I think I understood some of your comments, one thing to remember is that when you have access, if an institution has access to works through a database subscription, then we're really talking about contract because the database subscription agreement will govern. The copyright law won't. There's a big debate. I'm involved in the Copyright and Other Legal Matters Committee. I'm a member of IFLA's committee. And there's a big debate internationally about allowing what they call trans-border sharing, so that if a university had a subscription, like UWM has a subscription here, but a researcher in another country wanted an article, that we would have rights to still share an article with them from that subscription. It's not clear in all databases that you can do that, and even in the absence of a database subscription, there's still debate between the publishers and the user groups under whether that's lawful under basically just the copyright law. I mean, I would argue that it is, but it's not clear, and some publishers are questioning that. And that's why we're trying IFA to suggest to WIPO that we have a new copyright treaty for libraries, a new provision that gets in the form of a treaty that then other countries will implement. So it's a debatable issue depending upon who you ask. Yes.
So to make sure I understand the transformative versus the substitution use of something. So let's say I'm a student. I get 3 different books through interlibrary loan. My time is over to return them, and I decide I'm going to make a whole bunch of photocopies of these books because I'm not really done with them. If it was a textbook that I need to have the rest of the chapters so I can finish the semester, that seems like I'm pretty much toast. If that came up, that's not a fair use kind of a thing. That's clearly substitution. It prevented you from buying the book.
Purpose. Unless we're just like one chapter. The factor shifts. I mean, I could give you a scenario of something that's totally not transformative, but it's such a small amount, such a small portion, that we would say there's no market impact and things of that sort. But yes, I think your initial.
But let's say it's okay. So my second book then is some kind of a work that I'm writing my senior thesis and I'm doing an analysis of this book or whatever. So my purpose is to critique it or whatever, and so I take some of the chapters and I copy those and I'm using them as a source. That seems to be a little safer because that's more
and you're really critiquing it. Yeah, I mean, think of another example. Suppose that suppose this is a class in educational psychology in test design. And if I were, and say there was another class where, I want to use a test. So I'm the teacher in the second class, and I just make a copy of the test for each student. Clearly infringing. But in the first case, I make a copy of the test for each student, but then we're going to critique that test and redesign it. And, because the test publisher wants people to buy the test to use it as a test. They don't publish it so other students of tests can critique it, analyze it. So I think if you're right, you're really doing the kind of analysis, critique. You're really going through it page by page, line by line, and making that kind of analysis of it or reflection on it. I think conceivably you could say it's fair use.
If it was something maybe for personal use, I ILL a how to knit book, and okay, I'm not quite getting this. I need to use the diagrams every time, so I'm copying that. That seems like, again, that's about like downloading music. That way it's...
Yeah, and again, it depends, how much, you still have to ask for how much test. So, is every diagram really its own work? Generally, I wouldn't think so, but maybe. And then if you say, well, no, it's simply part of the whole book, and these amount to still like only 5% of the book, then that's still really not, you're not substituting for the purchase of a whole book. Whereas if you did the whole book because you wanted a reference book on knitting for yourself or whatever it was, then probably that's pretty much a clear substitute. Yeah.
This is less of a question about the law itself and more a question of dealing with copyright as part of negotiation.
Yes.
In talking either, and these might be two separate questions, but in talking with publishers, either journal publishers, like Elsevier or whoever, and then in talking with a university that might be interested in hiring you as an author or as a work producer, how much leeway do we generally have in actually dictating the terms of the copyright agreement, or is it just?
Yeah. Some publishers are harder to negotiate with others. In terms of what they will give. If you're looking to publish articles, and I know we're already talking about like this last paragraph on the second box of the page, and it goes to the point. It's really important nowadays to make sure that if you're going to publish, you're entering into negotiations with an author, with a publisher, and they're going to publish a chapter or they're going to publish an article, that you retain rights for yourself to continue to always use it in your own educational endeavors and your own work, and probably for your university. So that if the university is trying to create a repository of faculty publications, the university has the rights to do that. Elsevier doesn't like to do that. There was a special edition done probably 20 years ago now in JASIS on copyright. And Kenny Cruz and all the big names where I was just starting out, but I remember that edition. And I remember talking with Kenny Cruz about it afterwards. He said we almost didn't publish it because Elsevier would just not want to give us the rights to have, they wanted the exclusive rights, no other rights retained by the author. So there are some publishers that have reputations of not being willing to do that at all. And I think there they were able to get a little leverage out of Elsevier because they said, all right, well, we're pulling the whole content. Basically the whole content from that issue. And then the editor got involved, and the editor said, well, we need to go to press. So it's harder with some, definitely.
There are only 5 minutes left. Maybe we can ask the students, because that's also a meeting with the dean. So if you have any questions.
I thought it was 12:30 to 2:30%.
No, true.
Well, you have my. If you want to look at this, you'll see this. Here's the actual language from the contract, and then here's my comments about the language. So it's kind of maybe a self-help tool. Happy to do some follow-up or something. There you go. Yeah, you have someone on staff who's a copy.
I like even the phone number.
No, I don't. It's on your phone.
It's pretty
I
good.
it's always doing that.
The coupon's still count.
It's still counts.
Okay.
You think you can find
Find
it?
the phone number. I think Evelyn actually has a. I think if you call it, was it General Dean's number, and it goes to Evelyn, and you'll feel it.
But Evan's going to charge you. You're not charging, but she's charging.
No, you got to talk to Evelyn. She'll get it.
So we have a couple of minutes. So do you have any questions for the dean?
Dean questions.
Yeah, the dean's question. There are always a lot. Don't be quiet.
But still my question is in the presentation. Can I?
Sure, that's good.
There are a lot of literature exploration, a lot of writers, a lot of things everywhere in the world. You see internet, Google Scholar, a lot. How can this copyright law really track all these things? It's so much. The titles are so variety, whatever is here. And we are looking at the concept that information is free, and somehow the idea are generated from ideas and ideas, And still, I look at it like an auto benefit sometimes if you wrote a book, you got incentives, and the publisher continued to gain, while the recipient, suffer, and it somehow look like a cage, or somehow. So what I'm trying to say, is there any provision like a waive, like somehow there are some publication you have a right to do whatever you want as long as you quote and you have a reference, but
I wouldn't try and look at it that way in the sense because there are standards of academic integrity about sourcing the material, things of that sort, which are very different from the copyright law. I mean, for example, if you were to use, and there have been famous cases in the news about this in the last decade or so, you could use a sentence and you could fail to give it any source, and it's caused controversy for some scholars that they were accused of academic misconduct. That would never be copyright infringement. On the other hand, you could quote really a large part of a book, give the source, and it wouldn't matter in terms of copyright infringement. It might be infringing, even if you gave the proper source. So you kind of can't think of them as the same. I think what our fair use law in the United States is doing, especially when you look at the Google book search cases and those types of cases, is it doesn't ignore the rights of authors, but it says that this tool of functionality, this tool of how to locate information, in a sense, that is really preserving that information is free idea. You can't read the whole book on Google, but you can identify where the information is. So it's trying to kind of maintain that balance between access and still maintain some incentive value for authors. And that's why around the world there are some countries that have adopted fair use. Israel and Japan have enacted fair use. And there's a very famous copyright scholar in Europe, Bert Hugenholtz, who has advocated that European copyright law needs to evolve and it should consider adopting fair use. Because I think fair use gives more of that breathing room. It still maintains authors' rights where that is really their market, but it says that other markets just aren't due the copyright owner. That transformative market, I think, is really it tries to embody that sense of information is free. It doesn't maybe do it to that extreme sense that it's completely free. It's not without some cost, but it really tries to promote the access to information.
I think we're exactly, there's a class.
How many minutes? Okay.
Yeah.